Welcome to turning a moment into a movement.
This little light of mine, I'm gon' let it shine. I'm gon' let it shine. This little light of mine, this little light of mine, I'm gon' let it shine. This little light of mine, I'm gon' let it shine. I'm gon' let it shine. This little light of mine, I'm gon' let it shine. I'm gon' let it shine. Oh Lord, just let it shine. This light of mine, this light of mine. Oh Lord, would you please just let it shine. Take the drama out of my life. Oh Lord, every night, the pain ain't right. I wake up at night, I never sleep. 26, 10, and 7, that's just me. Every day I need a little seed. I need a little fresh air, man, I need to breathe. All I know is trauma, all I know is tickets. All I know is no visit. All I know is a mission to get straight up out of prison. Lord have mercy for me. Lord have mercy on my people. Preacher Mary Washington and all my real. Lord have mercy with my people. I pray to God, we really need you. When I was down bad, when things weren't going right, every time I prayed at night, I put my hands up in my face. I said, Lord have mercy, little light of mine. Lord God, please let it shine. It's the drama that I live in my life. I swear to God, I was a bad guy every night. 10 toes down, salute. Everybody suffering, everybody who trying to make a way. Everybody looking for the sky, everybody looking for that piece of pie. In a law library, I know what that feel like. Hoping that somebody get active and involved in your situation. Man, pop your collar and pray. Cause Lord have mercy on my soul. And they make bad guy father get out soon. And the rest of those brothers who be mobbing to child each morning. Oh man, I ain't going to this afternoon. Man, I'ma miss dinner today. I got a couple of noodles. Hey, you know what that feel like? Yeah, you know what it is. And if you a victim of a wrongful conviction, suffered and served by Ken Worthy, then I know that you know what that pain feel like. And your mama know what that pain feel like. Your father know what that pain feel like. With that light, let that little shine. Let that light shine, a little light of mine. Bad guy, doughboy, we all these great people in this great world of ours. 10 toes down, salute. I appreciate you, bad guy. I appreciate you, we. I appreciate the tech. I appreciate everybody in the studio. We gonna pop off that LV. Ooh-wee. Cause that's what they be liking to see. But I hope you hear the missing when you see me fresh. Salute. Salute. You do good, brother?
Greetings, everyone, and welcome to Turning a Moment into a Movement. I'm your host, J Love, and as always, we're grateful that you join us for another critical conversation on truth, accountability, and justice. Tonight, or this evening, we're going to be diving into cases that raise serious questions about what happens when the foundations of justice, evidence, itself is compromised. So what happens when the evidence is withheld? What happens when information is delayed? When the process that is supposed to ensure fairness becomes the very thing that's undermined? So we're going to be talking about two different cases. We're going to talk a little bit about the Ewing Searcy case, and then we're going to talk about another case, Kevin Deshawn Sykes. The court reached a different conclusion on his case, and so we're going to have Ms. Diane talk about that. So thank you for joining us. We want to talk about our mission while we're here every Saturday now. We're here. Turning a Moment in a Movement was inspired by the wrongful conviction of Gerard Haycraft, my son, and was built from the urgent need to create a self-empowering space for all those who have been harmed by injustice. Our mission is to shine a light on wrongful convictions, over sentencing, and neglect of those who are mentally ill and medically frail within the criminal legal system. We are committed to uplifting voices and sharing truths and advocating for those too often silenced. Through education, community organizing, and courageous storytelling, we work to disrupt the systems, policies, and patterns that fuels injustice, transforming awareness into collective action, and turning every moment into a movement for real change. Thank you for joining us again. And this week, Revertia is here. Hey, Revertia. Turn your mic on.
You would think I would have that down by now. But talking, how are you? I'm so glad to be here today. It's a wonderful time for us to come together. Yeah, we need to talk about this because a lot of times people don't realize how important it is. I'm coming to you from the choice zone where your choice matters. And I am lifting up justice everywhere that I go. And I believe that we are really making changes. And change happens on an individual level, and it also happens on a collective level. And I believe the individual level of change is most important because it can reach so many people just where you are. So, Jay, I'm just excited to be here tonight. And I thank you for having me on. Thank you for what you do and everything that you are in the community. I appreciate you.
Yes. So I was so let's talk about two things before we get started. One, yesterday I was with Trisha and we were at U of M with the students, and it was an amazing opportunity to learn more information about Crystal Clark and what goes the issues at Huron Valley. And it was a really great program. The students did a great job, and I want to commend them, Trisha as well. We were, after the presentation, we made signs and we were outside on the campus at U of M, holding up our signs and, giving out information about Crystal Clark. And so I just want to let everyone know that we're still, fighting for Crystal to be released. I talked to her this morning. This week has been a bad week, I think, because of the changes in the season now. It's getting warmer in there, and they're doing all kinds of stuff, moving people around. They've been doing some testing. And so running fans, which all of that stirs up the mold. And so she has been coughing a lot and like a really bad cough. And it's been like hard for her to breathe, but she's in good spirits. And so I want to let people know, if you want to know more about Crystal, on the screen, I put her link tree there. Her link tree, for those who might listen to this and can't see it, link tree fighting for Crystal Clark. And if you go there, you'll find out more about Crystal Clark, the fight for her freedom. The reason why we're fighting for her freedom, she's inside Michigan's only prison, highly allergic to mold. And for 15 years, they didn't do anything about it. And because of that situation with the mold is physically growing out of her body. It's growing from the inside. It's coming out her ears. It's growing up her legs now. It's going around her ears, on her arms. And so what we're trying to do is to bring more awareness and plead with the governor. I don't understand why she's not responding, but we're pleading with the governor to give her medical clemency or clemency, commutation, pardon, whatever, whichever one she chooses, to free Crystal. So that was yesterday. And today conversation, I went to the hearing, and I want to play this before we bring on Miss Diane.
Yes, yes.
Here we go.
In more news tonight, a Detroit man who was released from prison after a judge determined he was wrongfully convicted of murder says he continues fighting for his freedom. And critics are saying it's because the Wayne County prosecutor continues making him a target. Local 4's Demond Fernandez has been following this case for us. He joins us now with an update. Demond.
All right, Kimberly. So, 2 years ago, we watched Darrell Ewing walk out of jail a free man after trial judges overturned his murder conviction. He spent 14 years behind bars for murder before the court said he was wrongfully convicted. Well, Wayne County prosecutors appealed that decision, and today all sides were back in court with Ewing and his supporters bringing a strong message for the Wayne County prosecutor. It's yet another hurdle crossed for Darrell Ewing on what he's calling an ongoing journey to reclaiming his freedom.
Y'all keep on wasting the court's judicial resources and time. It's time to get right.
Ewing and a crowd of supporters speaking out against Wayne County prosecutor Kim Worthy and her office moments after an appeals court hearing on Tuesday. That hearing over a murder conviction against Ewing, which a trial court overturned 2 years ago. Prosecutors argue the trial court was wrong in releasing him.
Y'all wasting the people's time and y'all hurting the victims by keeping on prolonging cases that y'all know are clear cases of innocence. Look at all these men that stand here. This is the innocent man that's been declared. This is the innocent man that's been declared. This is the innocent man that's been declared that did time. And there's many more.
Ewing served 14 years in prison before judges determined he was wrongfully convicted. He's now pursuing a law degree and acting as an advocate for other men and women fighting wrongful convictions. Cases some in this group say are being handled by the same Wayne County prosecutor.
You're responsible for wrongful convictions. Instead of releasing the people and allowing them to go on with life, you're just trying to charge out the taxpayers, do the taxpayers dirty. So fire Kim Worthy.
Wayne County prosecutor Kim Worthy issued a statement saying, "My office makes determinations whether to appeal on a case-by-case basis after examination of lower court rulings and the legal and factual issues involved. Prosecuting attorneys have a right to appeal adverse rulings, and my office makes decisions that we believe are merited and in the best interest of justice." For Ewing, he says he remains forward-focused as the prosecutor's appeal plays out in court. After Tuesday's hearing, he gathered a group of attorneys, exonerees, nonprofits, and advocates to provide legal resources for the greater community. You and your supporters are trying to send a strong message. What do you want folks to know?
The thing is, it's all about getting it right. We aim to get it right. Anybody that's aiming to get it right, it's some individuals that I would never want to stay next to my auntie, my dad, my friends. You hear me? That justice must be done here. But when it's an injustice, you have the duty to correct it, not to continue to prolong it.
And we learned law students with the MSU Public Defenders Clinic are helping Ewing argue his case. For now, all sides are waiting to see what the Court of Appeals decides.
Yeah, let's bring on Miss, with that being said, let's bring on Miss Diane.
Yes.
Hi, Diane.
Hi, hi, Jay and Reverend Tia. Good to see both of you.
Oh, it's good to see you.
Yes.
So, Miss Diane, let's talk about that case. And that
Okay,
yeah. But
first thing I should probably say is that they hadn't caught up with the fact about 2 weeks later, after that tremendous hearing where so many people turned out to support Darrell, and that's what it's going to start to take everywhere, because the whole system in Wayne County and the state of Michigan is totally corrupt. But he won. He and Ewing Searcy, his co-defendant, the Court of Appeals, in an unusually fast ruling, 2 weeks later, issued a resounding ruling affirming the judge's dismissal of the charges. So the question becomes now, what's the next step? At the hearing, the judges talked about whether the appeals court judges talked about, well, you know, they didn't understand why rather than appealing the case, they could have just refiled the charges because it was dismissed without prejudice, which means you can file the charges again. So that's one option as to what could happen. The other option is Kim Worthy could appeal to the Supreme Court, which is her modus operandi in most cases. She's got an automatic appeal button right next to her bed, I think. And, you know, if you notice, you know, one thing I always notice when they show that picture of her that was on the video, oh my God, that was her campaign photo. She almost looks white there. They photoshopped her face to make her more acceptable to people. And that reflects on her concern for the entire community in the city of Detroit. She's been a long time opponent of juvenile life without parole, of the decisions overturning juvenile life without parole. And numerous, Wayne County probably has the highest number, second highest number of wrongful convictions in the country.
Yes.
But I was glad to see that the media, the mainstream media this time did confront her, because most of the time she's got the whole media on her side. And it was good to see that. It was kind of, you know, the courtroom was packed, and that made a big difference. Hopefully the movement that Darrell is starting, along with his family and the family of Derrico Searcy, will make a difference now. I did want to say that, well, Derrico, that's one thing that we need to know about, because really his case wasn't covered in the TV coverage. It was a case. Derrico won the case too. That's his co-defendant. They both have their convictions vacated still. Now, Derrico is still in prison serving, let's see, 35 up to 70 years, I think, or it might be 40 to 80 on a charge that stemmed from an incident after the following year, 2011. And he was cited as a habitual offender in that case based on this case. Now, this case has been vacated, and he had a previous charge of first-degree murder in 2005, but he won that. The jury acquitted him. So people need to remember him and his family too, because he's party to this whole situation. His attorney is Blaze Kearney. He spoke for Derrico at the hearing, and he's a very skilled attorney. He did a good job, and he was supposed to, when I talked to him in 2024 after the charges were dismissed, he was talking about at least getting a resentencing in Derrico's case, because it was falsely based on habitual offender. So, and one other thing I want to point out too here. Well, the other thing that was brought to mind when I was at the after event, and I asked the lawyers there, because there's a difference between with prejudice and without prejudice. Now, their case, the difference is that when a judge dismisses a case with prejudice, it cannot be brought back again. Now, in Derrico Searcy's brother's case, Thelonious Searcy, Sean Searcy, that judge, Thomas Hathaway, was totally outraged at the shenanigans of the Wayne County prosecutors, in his opinion, dismissing charges against Sean. And he just basically slammed down the hammer on him and said, look, I'm dismissing this with prejudice. Basically, I can't see that he's going to ever have a chance in this court to have a fair trial. And that was challenged. They appealed that. Kim Worthy appealed that. They got a kangaroo court of appeals panel that claimed that the judge did not have the authority to dismiss with prejudice. Now, that's a question of a judge's discretion. That's one thing that was raised in the Court of Appeals opinion. It's attached to the story that in Voice of Detroit, the Court of Appeals final opinion on the case. And they raised the issue of the judge's discretion. They said the judge in their case did not abuse his discretion when he dismissed the case without prejudice, because actually the prosecution could have brought it back again. But the issue is actually, does a judge have the right to dismiss a case with prejudice? In Arizona, that case, it was New Mexico. What was the guy's name? Alec Baldwin's case. When he was up there, he was charged for the killing, for the accidental gunshot shooting that he did of a woman on set who died. And the judge gave a definitive ruling in that case, dismissing it with prejudice because the prosecution had withheld evidence, and citing numerous cases from around the country as well as New Mexico that said that the judge has that right. And some people have said, well, you know, it doesn't apply in Michigan. That's bull. That was a Brady claim. That's national. And so that still needs to be challenged, really, because at least that would stop the courts from, or the trial courts from, just continuing with the charade of charging people and appealing, even when they know they're innocent. In Darrell's case, they knew from the beginning. The feds were involved on it. They brought in a witness that talked about the actual perpetrator of it, and to testify. They wouldn't let the witness. Tyree Washington was the perpetrator, according to many accounts in his account. And that was at the beginning of the trial. And they refused to take that into account. They refused to let Tyree Washington testify. And they've gone through this whole situation all over this almost 2 decades now, where they are fighting like crazy to lock Derrico and Darrell back up. And this is their MO. This is what they do all the time. In the case, I always, when people wonder what Kim Worthy's going to do with something, I always point to the case of Marianne Gaboldo. Now, people may remember, especially in Detroit, in 2011, Marianne Gaboldo was a woman that was the police, including helicopters, tanks, etc., went to her home where she was living with her 13-year-old daughter, who she was weaning off a dangerous medication. CPS, Child Protective Services, had decided that she should not be weaned off that medication, although they weren't the parent and they weren't a doctor. And it turns out they didn't even have the judge's authority. The judge never signed the order to take her out of the home, but they took her and they charged Marianne with a bunch of felonies. Marianne's charges were dismissed by 2 judges. First in the district court, 36th district, and then Judge Gregory Bill. Both of them did this twice. Judge Gregory Bill in the circuit court dismissed the charges as the fruit of the poisonous tree because of a lack of the judge's order. And Marianne had to fight about custody of her daughter still. She was still continuing the battle. Kim Worthy kept appealing and appealing and appealing, and finally she got the state Supreme Court, which was a different natured court back then, and they agreed that the conviction should be reinstated. The night before that, Marianne, who was a global hero by this time, had a major aneurysm and was disabled and died 6 months later. So Kim Worthy basically prosecuted her to death. And it's incredible. You know, that was a mother and child. Kim Worthy was a mother with a child about the same age. And she did that.
That was a big case. I remember them
Yes.
showing it on the news when they were all at this lady house, like she
Right.
was a serial killer or something. And
Right, right.
police and everything at the lady house. That was crazy. So, and even
They
with
took it. Yeah, go ahead.
Tony's case, with prejudice, right?
Mm-hmm.
And he still has to go back to court in May, right?
Yeah, he's still they since the issue with prejudice never really got addressed in the appellate process, so it's back in the retrial basis now. But he has got a judge that people should remember, Michael Jackson Bolanos, the young, well, in his 40s, the young black Detroiter that was basically framed up for the murder of Samantha Wool, the synagogue leader in downtown Detroit. And a lot of people watched that. And that was a case where it was clear that they had no grounds to charge him with her murder. The attorney, Brian Brown, and his, I forgot the woman attorney's name, but they made it clear that there was no grounds to charge him with the murder. He happened to be in the area. He was walking around, seeking opportunity, on parked cars, basically. And he happened to run across her body in the sidewalk. And he left immediately because he said he didn't call the police or anything because he knew what would happen. A black guy, finding a white woman's body there in downtown Detroit. And but the jury acquitted him of the murder charges, acquitted him of home invasion, which they had no grounds even to say that he even went in the house. And I don't know if you have my story up there on Darrell at the bottom, there video from Fox 2 News about with what Judge Margaret Van Houten said in that case.
Yeah. So that
do you want? I can play it here if you'd like off my computer. It was just astoundingly biased. If here,
so yeah, we won't be able to see it on your computer, Diane, but
you probably hear it. Yeah, you could probably hear it.
I can pull it up just a second.
Okay, I was this was the most astonishingly racist ruling I'd ever heard a judge give.
That is the same judge that was in Gerard's case.
Oh, is it?
Yes. Who said, although I read the everything that everyone said, because we did letters, we had letters from doctors and all. But anyway, she said, because a jury found you guilty, I just got to go with that. She didn't do anything. Then she told us that he would get health care, great health care. In Jackson. Which she did not. He did not get good health care at all.
Right.
It was just so much, but she's the lawyer. I mean, she was the judge. Margaret Van Houten. That lady was late every day. If she disgrace. Let me play it. I just brought it up, you guys. Hold on 1 second.
Yeah, you gotta hear her in person.
She's horrific. Let's see. Just 1 second, you guys.
And while she's talking, his attorney, Michael Jackson Bolanos, and his attorney are there just
while it seems
stunned.
like this is not a serious charge, when you add the habitual fourth offense to it, raises it to a maximum penalty of 50.
But it went out.
Yeah, we got something going on.
Well, here I can. Okay, go ahead,
guys.
Okay.
is, wow, this is
I
the
can-
first. Hold on, Diane.
Okay.
15 years.
Here we go.
And what I have to look at is not just the circumstances.
I'm going to
of the
mute
offense,
everyone.
but also the offender. And habitual fourth raises this up into a straddle cell, 0 to 22 months guidelines, and the 22 months would indicate prison. And although it is a straddle cell, I could choose to give him jail time or just straight up probation. But I also have to look at the number of times that the defendant lied. And I have to say, if lying was an Olympic sport, you would get the gold medal, sir, because you told lie after lie after lie throughout those interviews, interrogations, and even a few on the stand. And the number of lies does factor into this. Also, the fact that there were prior failures to comply with community supervision, both with an unarmed robbery when he was a juvenile and also for the fleeing looting. And not only was he removed from the Haida prison sentence at the Thumb almost immediately, but was given a sentence of 18 months to 5 years and served out the entire term and never actually achieved parole because there had to have been numerous misconducts that apparently Mr. DeGrazia had looked up, but were not included in this report. But it's obvious there were numerous misconducts for him to serve out his entire time and not get parole. And then the other factor I'm looking at is nothing to do with acquitted conduct or the charges that had to be dismissed pursuant to that case, but also to admitted other crimes that he admitted to on the stand that will never get charged. The breaking and entering into those cars and taking pictures of cars to send to people to help them steal cars. That's all additional criminal activity. And apparently Mr. Jackson Bolanos, at the time of this offense, had not learned his lesson from all of his prior dealings with the judicial system and the prison system, and was still engaging in theft crimes on the night that this happened. And that's what put him in this place to begin with, and ended up having him charged with the more serious crimes. So it is the sentence of this court that Mr. Jackson Bolanos be sentenced to a period of incarceration of 18 months to 15 years in the Michigan Department of Corrections with 243 days credit for time served. He must pay $68 state costs, crime victim assessment fee of $130, court costs of $1,300, which is the amount this court has estimated is the average cost of a case coming through this courthouse. It's my duty, sir, to advise you of the right to seek appellate review of your conviction and sentence. If you're unable to afford an attorney, one will be appointed for you. They'll be given transcripts needed to prepare your motions or an appeal. If you wish to seek an appeal, you have to sign and date your appellate rights paperwork and mail it to the clerk of this court within 42 days of today's date. Your client's already initialed the form?
Yes.
Okay, we will give him a photocopy to take with him.
And Judge, just for the record, you made a reference to my client lying on the stand. Like, that's unsubstantiated that he lied on the stand. That wasn't even alleged that Mr. Jackson Bolanos lied on the stand, but this court made reference to lying on the stand. And just for the record, Judge, he successfully completed his last probation he was on in 2018. So he demonstrated to the court that he does have what it takes to be successful on community supervision. If you're going back from 2013 when he's 19 years old, I mean, this is 11 years ago at his last probation that he didn't successfully complete it. 2018 was his most recent probation, and he successfully completed that probation, and they closed him out.
Sir, I've heard you out. He may have completed that one, but then he was out committing theft crimes the night of this event.
Okay, but
Judge, admittedly.
Okay, but Judge,
and he's never going to face charges on that.
Okay, so that's uncharged conduct, and Judge, if they wanted to charge him on it, they could have charged him on that. But in this building, Judge, we got to be honest with ourselves. How many individuals get sentenced to prison for lying to the police, especially if they're not being charged with any type of larceny? That just doesn't happen.
How many of those people are habitual fourth offenders? I'm done. That is my sentence. You can take it to the Court of Appeals.
Oh, well.
So this is a difficult case. We started with some
I don't know why I get upset all over again. It only takes a second. I go from 0 to 100. That is our system, judicial system is horrible. And it's because of
Diane,
the people.
you muted. Unmute yourself, Diane. She, this the same lady. It's she triggers me just watching and listening to her voice.
Yes.
Oh God, I didn't know that. I kind of sprung that on you.
But she,
she's the kind of, you see her out. It's on site. Site for her.
Yeah, even what she was saying about that had nothing to do with anything. She just made up a whole thing to put all this time on him.
She made up a whole thing.
They had recommended, the probation department had recommended, or the sentencing, whatever, whoever makes the recommendations in the Department of Correction had recommended 18 months probation. And should that racist B went ahead. Yeah. Now she's out of Dearborn Heights. She was served on the city council there, the white area of Dearborn, and all that. Also,
appointed judge by Snyder.
Mm-hmm. And this is what we're allowing to happen in our courts in Wayne County.
Yeah.
Ridiculous. So ridiculous.
Yes. That lady is ridiculous. She
might as well be South Africa.
Back to what she said in Gerard's case. Like, it sounds like there's two different people, but I just gotta go with the person that she didn't like and do nothing. She knew it was wrong, but she sentenced him to prison anywhere for something he didn't do. So, and when I saw that this was the judge, I could not help but tell Thelonious, I'm praying for you, because this is the same judge.
Yeah, I didn't know that he knew. Yeah, that you had dealt with her too, because I'm worried about what's going to happen with him. Now, she, denied their motion for a Daubert hearing because there's a question about a gun in the case, and they wanted to bring in experts, the defense, to testify about what the prosecution had presented, to testify from the defense standpoint. She denied that. It went all the way up to the Supreme Court, and they overturned that. So that's what's happening next, is a Daubert hearing, May 11th. But, these judges, in the case of, what time? How late are we on for this show, Jay?
We got time. We could go to the next case.
Okay. Well,
I want to ask.
I just wanted to throw. Pardon.
I got questions about that case too. Go ahead.
Yeah.
Oh, about but just quickly at the bottom of the story, I have a whole thing about that the assistant prosecutor in that argued at Darrell's hearing, Daniel Hebel, who's a right-wing Trumper type with the Student Statesmanship Institute. It's an institute in Lansing that stages multi-track week-long summer trainings for conservative Christian high school homeschooled young people in the basics of legislation, the judiciary, business, media, and election campaigns. It touts itself as Michigan's premier biblical worldview and leadership training program for high school students. And its slogan is inspiring teens to find their ultimate identity in Christ and their highest calling as his ambassador. Now, he was also the assistant prosecutor, and he's been in a lot of cases. His performance at Darrell's hearing was just abominable. He didn't quote any case law. He kept talking about, that stuff. When he was referring to evidence, he used that term repeatedly. He's also the prosecutor in Ricky Rimmer's case, and we've been covering that case for years now. He filed a brief that was full of falsehoods, misinterpretation, deliberate misinterpretation of case law. And, Ricky's case right now is pending at the Supreme Court. So we're hoping that maybe, because the felony murder situation. The Supreme Court in Michigan heard a case back in December, I think, or was it January? Anyway, they heard a case in the Edwin Langford, about the felony murder statute in Michigan. And that case involves a ruling from the Supreme Court in 1980 in Michigan that outlawed felony murder convictions, basically saying that, you have to prove the underlying felony they had intent to murder. And it was never made retroactive. So all these guys are sitting in prison, hundreds of them who were convicted before 1980. And it finally got back to the Supreme Court to address those people's cases. And we're hoping Ricky that's what he was charged with, felony murder. And there's other cases that are out here now too, where people are still facing felony murder charges. So, and the state of Pennsylvania Supreme Court just overturned it completely. They ruled that is not a legal conviction. So,
Yeah.
wait a minute,
Yeah, Diane, something happened to Diane.
Mm-hmm.
It'd be bad, but wow, Reverend Tia, this stuff is crazy.
Well, and because they've been in office in that position for so long, and people are not aware of the judicial stances that are the gatekeepers for the prison system, and we just act as if that's the way it has to be, that's the way it's going to be. But see, how many times have we started getting out in the open? She needs to be fired from her position. We don't have to keep her there.
Right.
We need to be looking up when is the time for her? When is the challenge time for her?
Right. So complacency is, we have to stop being so complacent. We don't do our due diligence. We just go with the nag. So she's been going on for years and years and years, and with no real threat. The only real threat that possibly happened to her was when Victoria ran for against her. That was the only real competition really for her. But doing all of this, these times when all these wrongful convictions, we know due to the federal oversight of the Detroit police, there was a lot of corruption going on. Mm-hmm. And so they fighting all these cases, and they're upholding the corruption that was going on that caused them to be under federal oversight in the first place.
They have not changed because they continue to have the leadership in the same position. They don't go after the leaders. They don't go after justice in those areas. The judge should not still be in that seat. Prosecution should not be in that seat. We need to look at these seats, and we need to target who are the individuals going after those seats who mean justice for the people. We need to put them there. We got to go to work on who are the challengers, because I don't know about anybody else. I'm about tired of these people making decisions that are detrimental for our community. It's terrible.
And Diane, what is going with the courts right now? We talked to about that before we started, but the courts right now is not a good for these wrongful convictions, is it?
Well, at the level of the trial courts and the trial courts in particular in Wayne County have had cases getting sent back to them. We have a list of about 30 cases where the cases have been sent back to Wayne County court judges, and based on violations of can you hear me okay? My phone keeps popping up and down.
No, we're fine.
Okay. And what was I saying about the 30 cases that they got appealed to the Court of Appeals. The Court of Appeals knocked them back to the trial court, and later some of them got appealed to the Supreme Court, and the Supreme Court knocked them back. The trial court gets them and refuses to do whatever they were knocked back for. Why the Court of Appeals said the ruling was, it was a improper conviction, whatever it was, and it's like they play yo-yo. They knock them back and forth, knock them back down to the trial court. The trial court refuses to do anything about it, so they appeal again, and then it gets knocked up to the Supreme Court, and it gets sent back again, and they still don't do anything. Wayne County judges under this administration do not think that they have to answer to anybody except themselves. And Kim Worthy's played a role in that, because she's terrorized some of the judges to the point where they just retired or left the bench, but that's the whole mentality that exists in Wayne County. And of course, the rest of Michigan isn't much better, and neither is the rest of the country, but right.
So what about Kevin Sykes? Is that, am I saying his name correctly, Kevin?
Kevin Sykes, right. Now you have that display of him and Vicky Yost and Eugene Brown and Lamar Grable. Vicky Yost, he's accused of shooting her in 2001 in the leg outside a cafe on the east side. And he was identified in court. Now, she identified him in a lineup. I said, I think that's him, and identified him in court again. But that was a mistaken identification. He was in West Virginia, and he has all sorts of affidavits to say that. The Michigan Innocence Clinic had his case. They located the actual the actual shooter in the case, and identified him, and he's written an affidavit. There's all sorts of information about, that he should have been, but there's a reason he's still locked up in there, and that's because of Vicky Yost to a large degree. Now, Vicky Yost, there's in some of the cases I've been reporting on, she's a private investigator now. She used to be a Detroit police officer. When she was a Detroit police officer in 1996, she and Eugene Brown were responsible for the murder of Lamar Grable, which was a cause célèbre in Detroit with the Detroit Coalition Against Police Brutality. And his mother, Arnetta Grable, was one of the leaders of that, as well as his father, Herman Valerie. They campaigned for years and finally got Lamar's day in civil court. Eugene Brown basically admitted that he could have shot him in the chest as he was laying down 3 times. In other words, executed him while he lay on the ground. That case, that was a jury verdict for $4 million in favor of the family. That was appealed by the Wayne County prosecutor. Then it was appealed to the Supreme Court. By the time it got resolved there, which they upheld the verdict as well, it had gone up to $6 million. But in the meantime, people lost their lives. Arnetta died back in 2016. Her health was drastically affected. Another member of the Detroit Coalition Against Police Brutality that worked with us on that, Cornell Squires, died in 2017. And his son was framed up by the police. I also did articles on his son, Cornell Emmanuel Squires. And after Cornell died, he was left without his father and 2 little toddler kids. And he died a few years ago. He was shot to death. We don't know who did it, as he was taking the garbage out in front of the home he lived in with his father, and on the southwest side there on Electric Street. So, that's the kind of tragedy that ensues out of all these wrongful deaths, these executions in the streets, these executions in the prisons. Basically, when they send somebody to prison for life, you're taking their life. That's what Ricky said in his case. The cop that framed him up, James Harris, that he knew what he was in retaliation to Ricky. He knew he was either going to kill him directly or kill him by sending him to prison for life, and that's what happened. And I'm just looking for the information right now on Kevin Sykes, because go ahead. What were you going to say?
I was just on the screen. Attorney Pamela Rice Campbell said they, speaking of the courts, keep remanding the cases because the trial court isn't following directives or not conducting evidentiary hearings.
Right. And in Kevin Sykes's case, now the Michigan Innocence Clinic had taken his case because of the strong innocence contention in the case, which was that he wasn't even in the state when that happened, and that he had a confession from another man on an affidavit saying he was the one that did it. The ID but Vicky O still testified against him at his trial, and I think Kevin's mother told us that, well, she seemed a little uncertain about doing it, but I don't care. That woman participated in the murder of Lamar Grable along with Eugene Brown, participated in covering it up. Inkster.
Brown name sounds familiar. Why is that name so familiar?
Which one?
Eugene Brown.
Lamar Grable. Oh, Eugene Brown, he killed 3 men in a series of, there was all sorts of coverage, news coverage of his story. I broke the story really in the Michigan Citizen. He killed 2 other men, Lamar in 1996. Prior to that, he had killed Roosevelt, I got his last name mixed up. He had killed another man claiming he had pulled a knife on him, which wasn't the case. That went to court, and that didn't go no place. And then he killed a motorcyclist, a white motorcyclist who was in the motorcycle club with his fiance, and he shot him through the door of the club and killed him. Now, there was a Walter Shoulders report from the internal, the police department asked Walter Shoulders, who was a deputy chief, and a panel of deputy chiefs to look into those cases. And they decided that, in fact, he should be tried for those cases. That was covered up by Benny Napoleon and them back at the time. And they refused to do anything to take action. Eugene Brown graduated from college, went on to retire from the police department, never spent a day in prison. And Vicky O, she took home the gun that they claim Lamar Grable had, which he didn't have. She took it home with her. It was one of the throwaway type guns the night after, the day of the shooting, and didn't turn it into evidence the next day. And there was, in a court of appeals opinion on in Arnetta Grable versus Brown, the court of appeals said that basically said that it was clear from the testimony at the trial that there was some kind of deviant police behavior going on. And so, that's been known. But anyway, 5 years later, here she comes, and she was involved. She's been involved in other cases too. That doesn't, anyway, in Kevin's case, the fact that, now, wait, I'm looking to see if I have this ruling on the, here's the Grable versus Brown information. Dr. Peters testified to inconsistencies between Yost's testimony regarding the manner in which the gun found near Grable's body was fired. Dr. Peters opined that these inconsistencies raised a serious doubt regarding the number of shots fired or what happened to the weapon as it was being examined. Dr. Peters found it odd that Yost's version of the event seemed to become clearer as time passed, since one's memory is generally fresher, closer to the event. Dr. Peters opined that the defendant's that's Eugene Brown, and Yost's behavior could be consistent with peer secrecy and deviant police behavior. So she was already on the record of having that was a case of mistaken identification, which was also the case with Kevin Sykes. That was a mistaken identification. And, he was living with his girlfriend in West Virginia at the time, and he'd gone down there. He was with her at the time of the killing. He was misidentified, and he has all sorts of affidavits to prove that. But the problem has been that Vicky Yost, in the intervening years, after she retired, or she quit. She became police chief in Inkster, and she quit after the Floyd Dent case, where William Melendez beat the hell out of Mr. Dent, nearly killed him. And there was all sorts of huge rallies and everything in Inkster back then. And so she had to step down as police chief then. And since that time, she's been running a private investigator case. A lot of prisoners use her. And I can't say she's, on some things, she does a good job. On the case that I just covered a while ago, David McKinney, I mean, she just really blasted the prosecutor's office, actually. And, she said that
Jones case, she is the private investigator for his case as well.
And James Jones, and how's she been doing in that case?
She did a good job for him.
I think she must be doing it out of guilt for what she's done in the past.
Right. When I saw
I'd never forgiven her for Lamar Grable.
I said, oh my God, wait a minute. This lady is a private investigator.
And she works closely with the Conviction Integrity Unit, with the prosecutor's office. The judge in Kevin Sykes' case is Patricia Frizard. Her husband, Dan Frizard, also works with them. And she's got ties to the state administration, the attorney general's office, and all of that too. Just like Kim Worthy, and is basically in bed with Dana Nessel and other actors that came out of the Wayne County courts. I believe the judge that was responsible for wrongful, not the judge, the prosecutor responsible for the wrongful convictions of a number. Her name just slipped my mind. They were protesting about her outside the courts for the last couple of years. There were articles in the Metro Times, but she went up to Dana Nessel's office and there's other prosecutors that have, and
so they just recycle all these people from one place to another. Like they do all these wrongful conviction stuff, then they get recycled to be investigators and all kinds of stuff for integrity units. And that's why people are saying this is why the argument for why integrity units should be separate from the prosecutor's office, with separate people with no ties to them, because it's the same people who have been accused of wrongful convictions or injustices or lies and corruption, working in the innocence.
Right in the Conviction Integrity Unit. Yes.
Right. And so when people, they have a right to say all of that when you hear all of this stuff about folks.
Yeah.
And what they do in the Integrity Unit, there was a case that I covered. Alfonso Clark, the Conviction Integrity Unit, got him exonerated and said he was wrongfully convicted. But the cop out of Inkster, which is where it was Inkster cops again involved here, they were involved in two other wrongful convictions, the one of David McKinney that I just mentioned, and another wrongful conviction, and I can't think, he's still in prison. The other guy, well, they both are. David McKinney's been in there forever, based on a totally faulty case brought against him about killing a gun shop owner in Inkster. And there's a whole story up on him in Voice of Detroit, so you can read that if you put his name in the search engine. But they don't, you know, in Kevin Sykes's case, the Michigan Innocence Clinic took his case. They were representing him back when he was in court for his previous motion for a new trial or motion for relief from judgment in 2016. And they were the ones that had found the guy that actually killed but not actually shot Vicky Yost, and had statements and everything. They were I thought they were going to take him into court representing him. But at the last minute, you know, they were leery about Vicky Yost's role. And they backed off, I believe, because of that. I was back and forth with them because I told them at the time, look, this Vicky Yost has a previous record of misidentifying people, criminally murdering people. And, you know, I sent them all the documents from from Lamar Grable case and all that. And, but they ended up backing off the case in terms of taking it to court. So right now he's Philip Komorski. He has an attorney named Philip Komorski representing him. And he filed a motion that under 770.1, finally we got an attorney to file a motion citing that statute, which says it's MCL 770.1. It's a state law. It's a state statute. 770.1, granting new trial to defendant. The judge of a court in which the trial of an offense is held may grant a new trial to the defendant for any cause for which, by law, a new trial may be granted, or when it appears to the court that justice has not been done and on the terms or conditions as the court directs. Now that's that definitely there. You look at that and you can see how the judge has discretion to dismiss cases with prejudice behind that. It's basically given the judge the authority to rule and to say justice has not been done, and I'm going to find this guy not guilty or dismiss the charges because it was a case of blatant injustice. And so that was raised in this opinion. I mean, it was raised in the motion, which is rare for a regular attorney to raise it because Travis Herndon has been raising it, our paralegal that works with the Voice of Detroit, has raised it for years. When they enacted MCR 6.500. That's what everything now is being filed under. And it's a court rule. It's a series of court rules that basically are an obstacle course to actually getting at the meat of the case and giving prisoners an opportunity, a clear path to get to the meat of the case. There's no way in hell all the technicalities under 6.500 can be followed by any people, and, people going to prison, not educated, people educated, young people. They can't follow those intricacies, but the lawyers keep filing everything under that. They have a ruling called Cress, which says about newly discovered evidence, which has 7 standards for what can be considered, 4 standards for what can be considered newly discovered evidence. And they're very restrictive. That's the standard under which Temujin Kempsu, they denied him under that. The conviction integrity unit in Dana Nessel's conviction integrity unit refused to take his case because he hadn't met the Crest factors. And the Crest factors in the federal courts, they don't recognize newly discovered evidence as a constitutional claim. So once you're through with the courts in Michigan, if that's all you've raised, you can't go to the federal courts. There is no way that they would take your case if you haven't raised a constitutional claim and of actual innocence. there's not, you know, all sorts of Supreme Court opinions that address that. And, you know, that you cannot put procedural bars in the place of actual innocence claims. Yeah. No.
So do you see, so Ms. Diane, so do you see this case as a failure of the legal system to correct itself? Or is this exactly how the system is designed to operate?
You know what? That's exactly, I remember when Lucino Hamilton was exonerated, and he was at a rally. He was one of the exonerees, but he's kind of a loner. He was at a rally in Lansing that Travis and I were at, as well as some of the other exonerees. And the reporter asked him, well, now do you think the system worked here because you're out? And he said, that's what the system was designed to do. That's what he told the reporter. And see, he's an abolitionist, basically. There's a whole group of people, criminal justice advocates for people in prison, that basically say that the prison system as it stands should be abolished, that there is no way it can even be really reformed. And it's at the basis. Yeah, go ahead.
I agree, Diane, because even with, you know, our fight for Crystal and her freedom, right? It's so many layers of corruption. It's too many layers to reform. You literally have to. For this thing to correct itself, it has to be all torn down because it's all based on slavery.
Yeah. It goes back to slavery, the prison system in this country. That's what it was based on. Slavery. That's what, under the 13th Amendment, it's still legal to force people to have slaves in the prisons.
Right.
What were you going to say, Travis? You want to add something?
Yeah, the only thing I was going to say is
this is Travis Herndon.
The only thing I was going to say is that the federal controlling law, Shelley versus Delo and House versus Bell on actual innocence, right? They states that if a person is raising a true actual innocence claim, there's no procedural bars. However, Michigan force you to come under People versus Crest. If you miss one of the Crest proponents, you lose. That is nothing but a procedural bar. People versus Crest. So how could I raise an actual innocence claim in Michigan when they're using a procedural bar on my claim? If I meet number 3 in People versus Crest, number 2, number 4, I could lose just by missing number 1. And that's a procedural bar. And Shelley versus Delo clearly says if a defendant is raising an actual innocence claim, the states cannot apply a procedural bar to it. But Crest make you come through Crest all the way through. And it's impossible to raise your actual innocence claim. That's why they're having all the problems they have on those actual innocence cases.
Yeah, in the case of Lorinda Swain, back in the Supreme Court in 2016, asked for opinion amicus briefs to be filed on the issue of whether 770.1 should be can be used to instead of 6.500, and a group of 6 attorneys, 6 prosecutors, federal and state prosecutors, including Saul Green and the Western Michigan. Saul Green used to be attorney for the Eastern District of Michigan, and another attorney for the Western District, and a number of other prosecutors hired a firm, and they came out with a brief in which they just totally blasted 6.500 as an alternative for prisoners. They said the whole prison system in Michigan is based on false pretenses, that and they analyzed 770.1. Now, Wait, I'm trying to find the brief because it starts out with this stunning. Oh, you got it right there. It starts out with this really stunning quote. It's the amicus curiae brief of current and former Michigan prosecutors John Smetanka, Thomas Cranmer, James Samuels, Thomas Rombach, Gerald Gleason, Saul Green, Fred Mester, Anthony Badovonic, and Brandon Halting. And the way it starts, this quote just always just blows my mind because they just totally deconstruct 6.500. Hold on one second. If it is not contrary to the law for an actually innocent person to be locked up for a crime she never committed, what value is the law? The wordplay of lawyers is mere pettifogging when aimed at keeping innocent people in prison. It is important to maintain perspective in deciding legal issues that strike to the core of justice. As Michigan knows well, even governors may become prisoners and prisoners governors. And any of the citizens in whose name a sentence is carried out today may be wrongfully accused of a crime tomorrow. That's from a Theory of Justice that was published in 1971. There was a Michigan governor that went to prison. But nobody truly believes that punishing an innocent person for a crime is justified by finality or to avoid reopening the wounds of victims, because nobody would accept such an excuse if they found themselves wrongfully convicted and seeking justice. And then they go through 70 pages of arguments in support of Lorinda Swain, who was convicted of child abuse. In what were you going to say, Travis? Add it in.
And that's what got Swain up in the Supreme Court. That Christian prosecutor you was just talking about. Remember, he tried to slide that in and make the statement that another defendant tried to raise under 770.1, but she was struck down. Yes, because he cited the 215 Swain opinion,
which was the Court of Appeals, which was overturned at the Supreme Court level.
The Michigan Supreme Court, based on that amicus brief, they granted leave and asked the bench and the bar 6 questions, 6 issues. And the last issue was, could a defendant file a motion for a new trial under 770.1 instead of 6.500? They didn't get to that question because they decided the case on the first issue in Swain. But if you look at it, when they sent the case back to the Court of Appeals, they said, make a finding not inconsistent with the trial court finding when he granted her relief. And the trial court found that she had been denied a fair trial, and that justice had not been done.
Under 770.1.
Right. And Swain sitting out there with 1.9 million. Now there was another case in 24 called People versus Selman. He filed a motion for a new trial under 770.1, and the trial court granted it. Kim Worthy appealed it to the Court of Appeals. The Court of Appeals told her, you're right, he shouldn't have granted relief under 770.1. However, the new trial stands, but he shouldn't have granted it. And right now he's sitting out there with I think $2.1 million that he got. And I noticed that each one of these cases came because they attempted to go under 770.1. And since the Supreme Court didn't answer that question, in actuality they did, because when they sent it back to the Court of Appeals, they sent it back for finding not inconsistent with the trial court. And the trial court found that under 770.1, justice had not been done. So in essence, when they sent that back, the Michigan Supreme Court basically ruled that you can file a motion for a new trial under 770.1. but none of these lawyers would take that issue back up there.
They're scared. They won't do it. And, once it gets back to the Supreme Court on that issue of 770.1 appealed like that, the Supreme Court will use that as case precedent.
Well, what you got to understand about that, in October 1st, 1989, the Michigan Supreme Court, with its supervisory powers over all state trial courts, told them anybody filing a post-conviction must file under 6.500. And so the court's been following that.
That's a court rule.
But it's a statute, 770.1, and it has never been overruled. Because if it was, the judge in Swain in 2015, how could he grant her relief under it if it can't be used in a post-conviction?
And that's the question of the separation of powers. The courts cannot overturn legislation. That's the legislative branch of government.
Well, we learned
except
that
if it's on, if
that in elementary.
Right, everybody knows that. The executive branch, the judicial branch, and then you got the legislative branch.
Who makes the law?
And in Sean's case, in Ewing Searcy's case, actually that was filed because Travis worked with him on the original motion for relief, and that was filed under 770.1 or in the alternative 6.500. So where was I going, Travis? You should remember about Sean's case being filed under 770. Oh, I would know. In the Court of Appeals opinion that threw out his conviction, they refused to consider it under 770.1 because they said 770, that the courts had overturned 770.1, which was a falsehood. But fortunately, they looked at Vincent's mother's testimony that he was the true perpetrator of the crime, and other ballistics evidence that was falsely presented at the trial by the prosecutor. And, and they still threw out his conviction. But now you see where he's at again. So, this whole system in Michigan has just been set up to make it, it's slavery all over again when you come down to it.
Right.
The numbers of folks saying. Mm-hmm.
Well, and the key is we need to be able to say, where do we go from here? I think it's important that people understand everything that people have been up against. And when you talk about, to just say you're in a place of democracy and it's fair and our system is different, then you're just following a narrative and you are not really understanding what has happened. And because the reason why the whole system needs to come down is because it's filtrated with people in leadership positions who do not have the capacity to judge without bias. And I don't know if that can ever be fixed, because that is a mechanism within their own brain that obviously, unless they have a great desire to do so, is not going to change.
Yeah, it can be fixed because look what they're doing. They're taking cases like Thelonious, who the judge already exonerated him, and they're taking it to the Supreme Court and bringing it right back. And so, despite what the judge is ruling, despite him saying that, you can't bring this back, they're doing it anyway. And guess
they do it anyway.
We're paying for this. The taxpayers, we're paying for our own demise. And so, once people ask us about, these wrongful convictions, right? And why does it take so long? Well, here's the reason why it's taking so long. Because these people are fighting it tooth and nail, and then the system is set up so you can't win. It's hard to win.
It's hard. It's hard to win when you have the people in power stacked up against you with a judgment that you've already lost before you even started.
Right.
It's ridiculous. And so when I want people to really understand that when you look at leadership from the executive level right now and making decisions and moving in opposite of law, opposite of decorum, everything that we're supposed to do in an executive position, it goes down to all levels. So in the smaller courts and the larger courts, people have been doing whatever they have wanted to do, making this and not following law.
Just like that judge did in Jackson Bolanos' case.
Right.
Yeah.
She didn't follow the law. She made the law. She said all that stuff, and she built his. She did listen to, and those people is the sentencing guidelines people that, you know, they tell the judge what they think. That she didn't listen to that because she let her prejudice. She let her prejudice against him and what was going on, because this lady at the time of this case was happening, because let's get some background on that. It was a whole big Jewish thing, and her boyfriend had already said he did it, and then they gave him immunity.
Well-to-do, right?
Yeah. So they had to make somebody the scapegoat of this because it was a big thing. It was a big thing going on. So she used her biases to sentence him to all this time, and that's what we're gonna later on. Me and Reverend T are gonna talk about the accountability piece.
Yeah,
there's no oversight for these judges, so they get to do and stuff like this. Put that on and send people 15 years. Are you kidding me? 18 months to 15 years, and they can keep flopping him. He can stay in there 15 years.
That's for lying to police. Now, people lie to police all the time. What are you going to do? You're not going to openly confess to whatever necessarily without a lawyer, for one thing. But lying to police, that's expected of criminals. I mean, people that are committing crime.
That's the other thing. The police can lie to you, and
exactly. I was going to say that. Exactly.
And they don't get in trouble for it. They
can
make up a whole story.
They're trained to do it. They're trained to do it.
Yes. So, Miss Diane, with Kevin's story, in your experience, what are the recantations or affidavits so often viewed as not credible by the courts?
Oh, that's an issue in all these opinions that come down from these judges that decide they can still decide whether or not something's credible. That affidavits are not credible. That's bullshit. That was overturned. What was that case? The guy
Hammock.
In Hammock, Robin Hammock's case. The Michigan Supreme Court said, in fact, I think it was Justice Kavanaugh, Justice Megan Kavanaugh, woman justice. Yeah, ruled that just because you haven't lived, she was talking to the white reactionary judge on the bench. Well, you may not have lived in the situations that poor folks and black folks, basically, and not these words, but she was saying this, have lived in, because the judge was saying, well, that's not believable that a 12-year-old child would have been out in the street selling marijuana and witnessed the actual people that did the crime. You know, and because there was an affidavit, and she said affidavits should be considered on their face. It doesn't matter. Even if another prisoner executed an affidavit for somebody in the same prison, they have the right to have that considered as a true piece of evidence, and to have evidentiary hearings about them. That's the key with a lot. In this case, Judge Prezard refused to hold an evidentiary hearing on there's all sorts of people that had written affidavits that needed to be examined in court. And there was another case recently where the judge also did that. The D.R.E. Hamilton case that Travis has been working on, the judge did the same thing, just refused to hold an evidentiary hearing. There's a number of cases we've run across. They will not listen to the actual people involved in the case. And in Ricky's case too, because he had two witnesses that could testify to how the police extorted the testimony against him in his trial, and they refuse to listen to them. They'll say things like, well, you know, that was 20, 40 years ago and they're just now coming out. Well, doesn't mean it's not true.
So this for you and Travis, in your opinion. So is the legal standard for actual innocence simply too high for most wrongful convicted people to ever meet?
The legal standard for actual innocence? Why don't you address that? Because,
well, the legal standard for actual innocence, the mistake that I find is happening is that Michigan lawyers, they rely on Michigan case law. You know, for example, if I already had filed a petition for a writ of habeas corpus in my case with the federal courts, and then I come back around through Michigan, and I raised the issue of newly discovered evidence. And Michigan, what they does, they use the People versus Crest, and guys be intertwining the actual innocence with newly discovered evidence. And so what a lot of people don't understand is that in People versus Crest, Crest did not win. When he went to the federal court, he tried to go back to the federal court for a second or successive aid. They told him, we cannot hear this case because you came up here with newly discovered evidence. Newly discovered evidence is not a federal constitutional claim. That is a state rule of law. See, so when these lawyers is filing this stuff with these guys, they talking about newly discovered evidence. And they're going to lose if they try to go to the federal court with it, because it's not a federal constitutional claim. And this is the position these lawyers putting these guys in when they do not raise it as actual innocence. If they raised it as actual innocence, then
look at the
People versus Crest cannot even help them, you know, because the Swain decision specifically told them you cannot use People versus Crest on a successive motion for relief from judgment at the beginning stage. And one reason for that is because People versus Crest got a diligent prong, which I think is the number 2. So if I raise the Brady issue, a Brady versus Maryland suppression issue, which do not have a diligent prong, how could Michigan hear my case when People versus Crest got a diligent prong? That's why they tell them now, you cannot use People versus Crest on a successive motion for relief from judgment at the beginning, you know, because Crest says you must show diligence. Brady versus Maryland don't have no diligent prong. So the state court cannot overrule the federal court. And that's why they did what they did there. And all of these cases coming back down from the appellate courts in Michigan back to the trial court, I disagree. My position is that they just don't know what they're doing in regards to the law in this area. You know, because like I said, I raised an actual innocence claim in the trial court. They make me come in the trial. You cannot file a post-conviction in Michigan without them using People versus Crest as the starting point. But if I'm raising an actual innocence claim, how could you use People versus Crest on me when the controlling United States Supreme Court case law says that a true actual innocence claim, you cannot apply any procedural bars to it. So when I come into Michigan courts and raise my actual innocence claim, they make me come in under People versus Crest. And Crest is nothing but procedural bars. 1 through 4 is a procedural bar. Anytime you could take it and say, if you lose on this first one, it's over with. That is a procedural bar. Because if you look at what Crest says, it talks about you could have raised the issue here, you could have did this, you could have did that. Yeah. And Shelley versus Dito says you can't use a procedural bar to block a guy. And actually, that's what Michigan did in 1989. Why would you take something under 770.1 when a guy could just go in the trial court and raise it and the judge could deny it or grant it? To change it to where you have to go through, I can't even really figure out the full 6.500 because it's too much. It's too much. You got guys in prison, and the majority of your guys in Michigan prison don't even have a high school education. So how could they sort through 6.500? It goes from 6.500 all the way to 609. And you got to get past all of this stuff. And the guy don't have that ability to do it. And it's clear that the trial courts don't understand it themselves.
Wow. So this are some legal minds over there. So
that's what I was saying about 770.1. Something I discovered a couple of months ago was it said the judge could grant you a new trial based on law. And then it says, or he could grant you a new trial if he find that justice has not been done. So that means he don't have to really deal with the law. He could say, well, wait a minute. The law got this guy trapped. He can't get out of here. But I know this guy has not received justice. So I'm going to grant a new trial. See? So when you look at or, I turned around and researched it. The Michigan Supreme Court, they gave a good example. They said, let's take cruel and unusual punishment. The United States Constitution, and this is what the justice wrote the opinion said. The United States Constitution says cruel and unusual
punishment.
Therefore, under the United States Constitution, in order to prevail on that, you must prove cruel and unusual.
Right.
But Michigan Constitution says cruel or unusual. And she pointed out that the word or is critical because under Michigan Constitution, all a guy has to prove is that it was either cruel or that it was unusual. There's no and where you have to prove them both. So when that statute 771 said the court may grant a new trial based on the law or blah, 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 or he could grant a new trial if he find that justice has not been done. So the or takes away the first portion of saying based on law. Because after they said that, they said, or he could grant it because he find that justice has not been done. So he don't need no law to grant the guy a new trial if he find that justice has not been done. That's the whole thing of it. See, so when they took this away and made guys come under 6.500, they took that away from guys. And then they're going to tell you every time you raise it, they're going to tell you it's been overruled.
Right.
And it hasn't been overruled. because it was just used in Swain in 2016. See, so it hasn't been overruled. That's just these judges down there, don't want to give a guy relief, so they tell you anything. And these lawyers, they go look at the court appeals and they go by what the state court said. They don't research and go and see how this stuff conflicting with federal law. Because you got a 14th Amendment, the due process, and that applies to the states.
Mm-hmm.
Yeah, let me interject something here too. Darrell's case at the Court of Appeals, what really struck me was that there was a lot of young people, at least young compared to us anyway, in their 20s and 30s, and that came out. And, they packed the court. There was an overflow room. They had an event afterwards where people spoke at it. And that's the kind of thing that really needs, I think that they would have won either way, even without that crowd, because the case was so bad. But that's not always the case with every Court of Appeals panel. And in Kevin's case, that's what he's talking about, trying to get together now. He wants to get together all his friends, people he knows, some of the exonerees, he knows all sorts of people in the system. And he's got family that supports him, friends that support him. His brother has been calling me. And he wants to mobilize to, he wants to mobilize like Darrell did. So he's also contacting Darrell. But
good, because you have to bring more public awareness into this, because really, honestly, people don't know. And I see so many people fighting wrongful convictions, and they're constantly bumping their heads. And you got to, like Darrell did, educate the community. The same thing we're doing with Crystal Clark. We're trying to educate the community, because this could be you. I looked at yesterday, Darrell and Butter, Larry, they're in Chicago at the Innocent Network, had a big event. And they had like this ballroom full of innocent people from all over the United States. That place was packed full of people who've been exonerated. That's just a small amount. That's probably like 2% of the
if that. Yeah.
If that, right. If that.
To be honest with you, my honest opinion of Darrell would still be in prison if he didn't represent himself when he went back to the trial court. If attorneys were to represent, Darrell would still be in prison. Darrell refused. He refused to accept Michigan law without federal law, and he did his digging. And now, just putting it point blank, he refused to do what the white people was trying to tell him to do. He went with what he knew and he understood to be the truth. And that's why he won. If it wouldn't have been him, if it would have just been his attorneys and he would have just sat there at the table with his hands folded, Darrell would still be in prison.
The other thing I wanted to raise too was this issue regarding young teenagers in Detroit. They've been publicizing supposedly how they're going downtown and disrupting events downtown, running their cars around and whatever. Look, kids in Detroit, Detroit has been so wholly gentrified down there. They've kicked out, the lower income people, black people, across the city, really, in the neighborhoods too, all the foreclosures and everything. The city has been transformed. And a lot of the black youth in this community don't have any future out there for them, and they know it. And that's why they just spontaneously do things like that, rebelling. And that needs to, I see the mayor is putting together a committee of young people to address those issues. But it needs to go broader than that. It needs to be an understanding of the entire plight that young people in this city are in. And you can address, some of it, but you need to welcome them into the embrace of the larger community, not demonize them.
Right. You can't criminalize them and demonize them because they don't have anything to do in the neighborhoods. So all you did is fix up downtown and make everything gentrified and beautiful for downtown. Guess where they're going? Going downtown.
Right. They have not been included.
Right. So I'm glad the mayor is taking a proactive stance, and she's addressing it, because this summer they'll be bopping them on the heads and putting them, and Reverend T will be seeing them when they come through her thing.
When they come in, that's right. That's right.
And so there'll be another cycle of kids.
Yeah, they used to have the community centers that kept youth very active, especially through the summer, and all these activities. And we need to get back to those kinds of things, because a lot of times children don't have anything that they're doing. They must be, have things they need to be learning and growing all the time, even in the summer. So I pray they start that again. You used to have all those activity centers that within walking distance from your homes, right there in the community, and they could do arts and crafts, they could swim, they could learn different skills that spruce up on their math and in English. There's so much that can be done, but we've fallen back and discontinued so much of that.
That's part of the whole privatization and gentrification of Detroit, the bankruptcy. They just completely demolished city services in terms of the recreation department, the health department, the water department, all of it. And that was a racist campaign that was conducted by Governor Snyder with these emergency managers across the state. The emergency managers were assigned to almost virtually all cities that were majority Black, or at least significantly Black, or people of color. And you see what's happened to Detroit in the neighborhoods. You go through Highland Park. It makes you cry. I go by, when we go down Woodward past the Highland Park Public Library, and it's all, boarded up and whatever. That public library used to have a basement full of Black history. Regional Black history. There was a Black history scholar that used to write at the Michigan Citizen, and I can't think of his name right now. But he said when they closed that library, they went and threw all those books about African American history into the dumpsters. He went and rescued them. And, to keep, but this is what they're denying to, young people in Highland Park could be going to that library still.
Yeah.
They closed the schools there. They closed schools in Detroit. It's just, it's been a definite dismantling. And that's all connected to getting back to the slaves ain't going to be educated. We'll make sure of that.
Right. And guess what? Michigan is 44th in the nation in education. So,
is it?
Horrific.
We've dummied down.
Yeah. Thank you, Diane.
We have been dummied.
We're gonna have to get you back, because I really want to get to Kevin's case.
Yeah, definitely.
His family or something. But don't log off, Diane. I left you a message in the chat.
Okay.
All right. So, Reverend T.
Isn't that something? When you talk about everything that has happened, what is surprising is that when a judge refuses to hear evidence, that is just mind-boggling to me. And they get to do it. They get to do it because they say it's irrelevant, it's repetitive, it's hearsay, or it's not disclosed like they said in advance, or it's outside of the procedural rules. But here's the issue. It becomes a legal issue, though, if it violates due process, if it prevents a fair hearing, or if it involves bias or improper conduct.
Yeah.
But how many lawyers go after that judge for those three possible reasons, you know?
Right. So when this comes to our segment, who we need to hold accountable this week, I think that we need to be asking the question, who is watching the prosecutors, right? Who is watching the judges? Who is ensuring accountability within the system? So because there's no real oversight, patterns of misconduct don't just happen once. They repeat over and over and over again. They grow and they go unchecked for years, which we're seeing. And when that happens, it's not just cases that are affected, people's lives are affected. So accountability cannot be optional for those who hold the most power. If no one is watching the system, then who is the system really serving?
That's right.
Yes.
Yeah, so, and it has to stop just serving the people at the top, Jay. I'm telling you, you're right. This is, and it's an eye opener. We gotta vote the right way.
Yes.
On all levels.
Yes.
On all levels. Yeah, we gotta hold them accountable.
How is there no evidentiary hearing in the Sykes case and a man confessed to the crime? So we're gonna do a part 2 for the Kevin Sykes case. We're gonna have Miss Diane come back again. We're gonna bring on the family and we're gonna dig deeper into how that conversation. Maybe we can get him on to talk about it, so we can really do a deep dive in it. Because it is, you see Darrell in their, case, and then you see this one, and it's just crazy. But like I said, if you looked at that his video, Darrell's video last night, and seen all of these people from all over the place, all over the country, it's just exonerating people. It was a eye sight to see all these people who were in prison for crimes they didn't do. It's my former team going. Hey, Edward.
Hey, Edward. Baraka.
So I want to, Reverend Tia, do you have anything to leave us with before we leave out of here this evening?
I just want to encourage everyone to continue to advocate. If you haven't started, pick a topic, pick us, pick Crystal, pick something, and do it with all your might. Do it. Join in with a group. We need to advocate around the issues that are affecting our community. And we cannot do it alone. Organizations can't do it alone. Just pick one, feel the vibe, and go for it. You will definitely make a difference. And Jay, I just can't impress upon that. I'm just so grateful for your advocacy and your stick-to-itness. Thank you so much.
Yes. And to learn more about Crystal, we have a link for Crystal. You can go to her Linktree again. That's Linktree Fighting for Crystal Clark. Here it is, Linktree Fighting for Crystal Clark. And learn more about Crystal. She's literally suffocating to death in the only women's prison in Michigan, Huron Valley, and learn about our freedom fight for Crystal.
Yeah.
And also I fight for all the other sick women inside of that place. Crystal is highly allergic to mold, and that place is infested with it. So, and Again, thank you for joining us. Next week, we won't be here because we're going to be out in the field working.
Yeah.
But we'll be here the week after. So thank you everyone for joining us, and we'll see you next time on Turning a Moment into a Movement. Good night.
Good night.
Just a light of mine. I'm gonna let it shine. I'm gonna let it shine. Just a light of mine. Just a light of mine. I'm gonna let it shine. This little light of mine, I'm gonna let it shine. I'm gonna let it shine. This little light of mine, I'm gonna let it shine. I'm gonna let it shine. Oh Lord, just let it shine. This light of mine, this light of mine. Oh Lord, would you please just let it shine. Take the drama out of my life. Oh Lord, every night the pain ain't right. I wake up at night, I never sleep. 26, 10, and 7, that's just me. Every day I need a little seed. I need a little fresh air, man, I need to breathe. All I know is trauma, all I know is tickets. All I know is no visit. All I know is a mission to get straight up out of prison. Lord have mercy for it. Lord have mercy on my people. Preacher Mary Washington and all my real. Lord have mercy with my people. I pray to God, we really need you. When I was down bad, when things weren't going right, every time I prayed at night, I put my hands up in my face. I said, Lord have mercy, little light of mine. Lord God, please let it shine. It's the drama that I live in my life. I swear to God, I was a bad guy every night. 10 toes down, salute. Everybody suffering, everybody who trying to make a way. Everybody looking for the sky, everybody looking for that piece of pie. In a law library, I know what that feel like. Hoping that somebody get active and involved in your situation. Man, pop your collar and pray. Cause Lord have mercy on my soul. And they make bad guy father get out soon. And the rest of those brothers who be mobbing to child each morning. Oh man, I ain't going to this afternoon. Man, I'ma miss dinner today. I got a couple noodles. Hey, you know what that feel like? Do you know what it is? And if you a victim of a wrongful conviction, suffered and served by Ken Worthy, then I know that you know what that pain feel like. And your mama know what that pain feel like. Your father know what that pain feel like. With that light, let that little shine. Let that light shine, a little light of mine. Bad guy, Doughboy Week, all these great people in this great world of ours. 10 toes down, salute. I appreciate you, bad guy. I appreciate you, we. I appreciate the tech. I appreciate everybody in the studio. We gonna pop off that LV, ooh-wee, cause that's what they be liking to see. But I hope you hear the missing when you see me fresh. Salute.